Good evening. It's Rick. It is September the 19th. It is the year 2018. If you need to contact me, you can do that by sending me an email, brief email, not long, to Rick, R-I-C-K, 0327@me.com. And you are sending me an email because you have a child support problem. Okay. Sorry, guys, I do not do custody. I do not do any other law. Traffic, arrests. I don't do any of that. Strictly child support. Okay. I've been getting a lot of emails for other stuff. Sorry, I only focus on one thing. Okay. All right. What we're doing today is I got some slides here, and what we're doing here is while your case is, whether it's just beginning or you're in the middle of it, or it just finished, or finished a while ago. Okay, what we're going to do is we're going to take it to them. So we're gonna do another collateral attack or direct attack. So what we're going to do is, if you're in a child support proceeding and you have, let's say you have my paperwork, or you're considering getting my paperwork, and I've done videos in the past where we've discussed what paperwork you're going to file before going to court, right? We're going to demand a trial by jury. We're going to demand the change of venue to a court of record. Right? The trial by jury, court of record. We're going to demand a writ of discovery. We want to view the evidence, okay? And whatever, any other rights that we're guaranteed in the Constitution, okay? So what we're going to do is now, if you already got a response or they're ignoring you, what we're going to do is we're going to file in another court. All right, we're not going to file it in the same court because they're going to ignore you. You're going to file it in a county court. Okay, you're going to file it in a county court or court of record. All right, so it's going to take a little effort on your part. You're going to find if the county court where you live in the county, where these proceedings took place, is a court of record. Hold on a second, guys. Sorry about that. I had a cough. And what we're going to do is we're going to enforce our rights. All right. Now, what you need, we're going to do that by filing a petition. All right. Now, if the judge or the fake judge, if you go before them and I just had a guy recently. The judge just basically ignored the filings, didn't answer any of them. See, that's the slick move. What they do is they don't answer the papers. All right, so they'll just say to dismiss. You want it in writing. You took the time to write these documents, even though Rick wrote them. Okay, but they don't know that, and you took the time to file them. You took the time to send copies to the other party. And the move on their end is they don't want it recorded that they denied you your rights. So you're going to demand, or you're going to file an objection, right? Demanding clarification for dismissal. Well, you have that paperwork already if you have my paperwork. All right. And then what you're going to do is now we're going to go to another court, another county court, hopefully, excuse me, a county court, court of record, all right? And we're going to petition the court, all right? So we're going to enforce our rights, all right? So we're going to look at slide 1 here. Enforcement of rights in courts is a First Amendment right. You have every right to petition courts for redress of grievances, okay? So, right, the First Amendment right, petitioning the court to enforce your rights against income withholding orders, okay, that's our cease and desists, right? Petitioning the courts against judgments and orders by non-judicial persons not judges, we call them fake judges, and they're also it's called quorum non judice. Okay, we've gone over that it's an adjudicated fact that any judgment, especially a money judgment, because these are money judgments, by the way, when they're stealing your property by these income withholding orders, they're money judgments, all right, and they're not final judgments, right, most of the time, and they're not recorded in the county clerk's office as a money judgment. They really don't exist. It's a piece of paper basically given to you in these nonsense proceedings that are there. Remember, I discussed it many, many times, and if you're new to my channel, I've described it many times. It's nothing but a production. It's just to make it look like it's a court hearing. It's not a court hearing, all right? It's fake. It's just a production, all right? It's not, first of all, you're not you're not in a court of record, all right? So you're in a Nisi Prius court where you have to object to everything, all right? Well, we're not going to do that. We're going to file petitions, all right? What is a redress of grievances? It's the right to petition the government for redress of grievances, the right to make a complaint or to seek assistance of one's government without fear of punishment or reprisals. All right. This is a landmark case, Miller versus United States, 1956. Well, not a landmark case. It's a strong case for us because they cannot convert a constitutional right into a crime. They do it all the time. All right. You have the right to bear arms. How many people are in prison for possession of a firearm? Well, that's because the state created a law that took away your right. Okay, now if that gun wasn't used in the committance of a crime, let's just say you had it on you or in your car, right? They consider your car like your house, or it's in your home and the cop found it somehow, they're violating your rights. Okay? They're violating your rights because they converted a right into a crime. All right? So let's go over this exercise of the constitutional right cannot be converted into a crime. Evelyn Miller stood on her Fourth Amendment rights. That's what we're going by the way. These income withholding orders are a violation of the Fourth Amendment. And she refused to allow a U.S. Marshal into her home without a search warrant. All right? Federal prosecutors charged her with obstruction of justice. In reversing her conviction, the court noted that Miller asserted a right which was hers and which none could take away. That it subjected the officers to the inconvenience of getting a lawful writ. Is that not what we're talking about, guys? All right? See, if these child support agencies claim that you owe them money, they're supposed to petition the court. Well, the way they do it is ass backwards. Is the bullshit family court or whatever court you guys are in? They issue a fake order. They give it to the child support agency. Then the child support agency writes one of their fake income withholding orders. And that's, by the way, that's hearsay. Okay? So they got to do it the right way. They got to follow due process. All right? Now, you need only understand by reading the English language to defend yourself, guys. I've been saying this. I've said this to you guys many times. Listen, I know how to read, right? Do you understand how to read the paper, black and white? That's all you need to understand. So if you understand it and it makes sense to you and you can articulate it, there is your confidence. I've had all the people that had success with my paperwork, they all studied and they were all confident and they went into court with a chip on their shoulder. All right? Because they understood the law. Okay? So long as you articulate the law, you're good to go. And that's what happened here. Like these lawyers all the time. Are you a lawyer? You don't have to be a lawyer. All right? So, read this case law because we're going to keep moving. I got a lot of slides. But just understand, all you need to do is understand the law. All right? Let's go over this. Whenever you see me do this, represent yourself because you're not representing yourself. All right? You are yourself. You don't have to represent yourself because you're already there. When you're standing in a court, you're there. You're there. So be oneself. Never represent yourself. Never. Entrapment, pro se. Here's another thing. If you're going to use common law, you don't want to use their terms. So pro se is a lawyer term. Okay, so be careful of that. All right, you don't want to say you're pro se. They do it all the time. All right, and I understand sometimes you have to just to get the paperwork through. All right, there's a lot of hoops you got to jump through. All right, so you might just say, listen, I am not pro se or pro per or whatever. Okay, if that's what you need to hear me say to get my paperwork through, but I'm telling you, I'm not pro anything. I'm a living human. Okay, there you go. You can read that. Okay, what kind of petitions are we going to file in the state court? We're going to file a cease and desist. We went over that. Okay, by petition a court for cease and desist to order a child support employer, bank, etc. to cease and desist. You are showing the court the many lawful reasons why a support order, income withholding order, are legally defective. Okay, I have a guy right now, and his employer is seriously, looking into not taking his money anymore. I mean, I can't give out the information because he's a little paranoid. I don't blame him. Maybe that close, but it's working in that. See, and by the way, because he filed the paperwork in the court. So what I mean by his employer is seriously considering it because they're supposed to show up to court in a couple of weeks, and the employer doesn't want to go to court. So we'll see what happens. All right. But again, the guy, I asked him, he doesn't really want to share. And what can I do? I understand. All right. The court will be on record for viewing evidence of a legally defective. So right now you're going to have it on record because you filed a petition telling the court that, oh, but hey, I need help here. I need to enforce my Fourth Amendment right that my property is being seized without a warrant. Okay? A judge is required by oath and bound by Supremacy Clause, Article 6, Section 2, and Article 6, Section 3, which is for courts and judges, I believe. All right? But don't worry, just look it up, you'll see. The judge is required to acknowledge statutes and adjudicated facts that prove an order is void for being legally defective. Okay, so if you're going to point out to a Judge 28 U.S.C. 1691 says that any judgment or order from a court must be signed by a clerk and entered in the county clerk or the clerk. And many of our orders are not signed by clerks, and they're signed by deputy clerks. It's void. There's a case law for that. Okay. Well, all right. Petitions to enforce due process. All right, we're going to file a petition to certify an order is void under Federal Rule 60B. 60B subsection 4 is usually Uh, Here's the thing, guys. Uh, Sometimes, and listen, I was guilty of this myself. I used to go for the jugular all the time, and I fraud, and I'd write fraud everywhere, fraud. Listen, let's just use the least uh, harmful word, because when you go for fraud, they're going to get very defensive, and you know they may not find for you. They just could play a lot of games because they're going to be protecting everybody. Let's just stick with uh, lack of due process, okay? Lack of jurisdiction, okay? Let's just go to the simplest way there without getting people all defensive, okay? Just trust me on this, all right? It's happened to me, all right? Um, Federal Rule 60B is relief from a void judgment, and every state has an equivalent law. So in New York State, we have CPLR 5015, subsection A, section 4 is the equivalent to Federal Rule 60B4. Okay, you're going to petition the court for trespass upon rights. We discussed this before. This is important. Um, As soon as your rights are being deprived, right? Remember I mentioned before, you filed a trial by jury, you filed a writ of discovery, and you filed a change of venue, and they're ignoring you, or they're giving you the old bullshit. Oh, we don't do trial by jury in family cases. Well, that's when now what you're going to do is that you're going to write up a petition for trespass upon rights. Okay? And you're going to do it in a state court. Guys, my paperwork is for state courts. All right. When you go to federal courts, there's just too many games they play. Now, I'm not saying not, I'm just saying if you're going to start in federal, stay in federal. We're in state courts already. All right. It's very difficult to go to state court. All right. This is just my opinion. All right. It's just my opinion, only because they have that stupid Rooker-Feldman nonsense, which is, another hurdle. All right. Because they're using that to protect these judges. All right. So here's the thing. You can file trespass upon rights under common law. Okay. In a common law court in the state, court of record. So you're going to look for a court of record in the state. Usually county courts are courts of record. They don't want you to notice, but you're going to force the court to act as a court of record. And you're going to do that by the paperwork. Okay? Wonderful. This happens. Whenever I get this white screen crap, for fuck's sake. Excuse my language. Sorry about that. Oh, boy. All right. So this is the one I just made up. All right. So look, it says notice of petition, trespass upon rights. Now what you do is you write CF and a period. That means compared to. So you're going to compare it to, so it has all the elements of trespass upon rights under the federal, but we're not going federal. We're filing it as a trespass under common law. Okay? And that's how we're going to do it. You're going to describe it. And see, we're going to leave this defendant, but what you can do is defendant, wrongdoer, plaintiff, right? Aggrieved claimant. All right. See, you can leave that there, and you just write it in the paperwork. Be advised that the defendant is going to be is renamed wrongdoer. See, we're doing that to appease these knucklehead clerks, because when they see that, they're going to kick back your paperwork. Just get your paperwork through. Okay? This is one of the things I had to learn, and that's why I'm here for you guys. I'm teaching you these things. Okay? Trust me when I tell you, they hire the biggest knuckleheads to work there purposely. Okay, they follow any orders, right? And we describe everything. All right, look at that bad boy. And that's what it looks like. But hey guys, that's how I get my gifts. So I can't. I know there are going to be some people freezing it and copying it, but again, you're better off sending me a gift to get everything that I have. Trust me, everybody that gets it, they'll tell you, read the comment section. I've never, I've had a couple of problems with people, but that's because there was something wrong with the person. Trust me, I have a 98. I would guess a 98% rate of wow. Okay, that's the response I get. All right. So what they're gonna do, and I'm skipping here. I apologize. That's why I'm saying you're better off just send me the gift, and then you're gonna get all the paperwork. Trust me, when you see it, you're gonna say wow. You're gonna know that the money was well, you know, invested. If you want to call it an investment. All right. Um, Now, when we're filing against a trespass, what you're going to do is now, because it's in a different court, they know that you mean business. So while you're going through the nonsense in family court, whatever the court's called that you're in another court, you're filing a trespass upon rights against this joker, all right, male, female, who thinks that you're a knucklehead because, well, we don't provide trial by jury here. Oh, the Constitution doesn't. I mean, I can't believe these people actually say this. And here's the thing: uh, after that happens, hopefully you have a witness. Hopefully you recorded it, or you have it in memory. Write it on paper really fast. Guess what? You add it to the petition. So then you'll say, on such and such day in such and such court, so and so stated on the record that the Constitution does not count, does not apply in this courtroom. You're not entitled to a trial by jury. You understand? And that's evidence against them. Okay. All right, we're sticking right. We're still going. What kind of petitions in state court? Trespass upon rights under common law. I just showed it to you. All right. CF means compared to. Thereby, you can charge trespass upon rights. You can refer to a federal statute without using it. That's the beauty of it. So you're going to say, well, he trespassed upon my rights, compared to the federal law. Okay. Petitioning the court is a counterattack against trespass upon your rights. Okay. So petitioning the court while you are defending yourself, really fighting for your life, right? Uh, in child support proceeding is a perfect counterattack. Okay. Now here's another thing. Uh, be careful when you file a counterattack, uh, especially for fraud. Here's the thing: if you do that, then you leave yourself open for the other side to demand discovery. All right? They may say, well, you filed the petition. We want to see evidence that you've been supporting your child. So be careful. That's a counterattack for fraud, claiming that the other party is you're filing a petition claiming it's fraud upon the court, because all they have to do is say, well, show us that you've been paying, and let's say you missed a payment here and there, or maybe you haven't been. Okay. See, when you're the defendant and they're the petitioner, they have to prove everything. Although, really, it's the other way around. But because you watch videos like mine and Amen and Fifi, Liquid Theory, you're learning. You know that uh, the other side, the petitioner, bears the burden, okay, of proof. Now the hard part is getting them to, you know, comply with that fact. All right. So here's some case laws, right? Federal law, Supreme Court cases apply in state court cases. Howlett versus Rose. Jurisdiction, once challenged, cannot be assumed. It must be decided. Petitioning the court for enforcement under the 14th Amendment, equal protection. All right. So another reason why we're petitioning, because you have a right to equal protection of the law. All right. And that's another weapon. All right. Orders issued by persons, not judges, are void under the violation of due process clause under the 14th Amendment. Petitioning the court to enforce violation of due process. Right. You have a right to due process of law under the 5th and 14th Amendment. Under the 14th Amendment, it's called the due process clause. Utilizing prior Supreme Court decisions, stare decisis, is a perfect defense. Okay, we were calling them adjudicated facts. Are perfect defense and offense against violations of due process. This is what we're talking about. Getting a separate court and court personnel involved can be useful against child support proceedings violating your rights, and can be articulated as persons acting in concert to violate your rights, meaning another court personnel may not want to get involved. So let's say there's some shenanigans going on in your child support matter. The court that you're in now, by filing a petition, they may not want to be a party to that. Okay? Because what's to stop you from filing deprivation of rights, conspiracy against rights under 18 U.S.C., which is a crime, 18 U.S.C. 241, which is conspiracy to deprive rights. When you got all these parties involved, so the people in the court that you're filing a petition may not want to be a party to that. All right? Case laws. All right? Case laws. Now, here's this is a very important case law. One of the ways they don't want you filing petitions. Okay, I've discussed this before, but again, maybe you didn't see the video, maybe you're new to my channel. How they do that is charging you these crazy fees. Okay, in New York, it's like $300 to file a petition in a county court. Okay, now it's an adjudicated fact. And it's law. When the Supreme Court decides, makes a decision, it becomes law. Okay, so here is a piece of the case law from Crandall versus Nevada, Supreme Court, 1868. He has a right to free access to its seaports, through which all operations of foreign trade and commerce are conducted. Right, blah, 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 blah. And the courts of justice in the several states. And this right is in its nature independent of the will of any state over whose soil he must pass in the exercise. Meaning the state cannot pass a law causing you to pay to access the court. Well, that's really the 14th Amendment, right? The 14th Amendment, the state cannot create a law to deprive you of your right. So right there, you present this snippet right here, right? I have it here. Please cite the Supreme Court decision to the clerk's office to avoid petition fees, okay? It's very important. We don't want to pay these fees. All right, here's another thing. When you file a petition, a lot of you guys, this is very, very important. You have to add a return date, okay? A return date is usually 30 days. And the reason why you're doing that is you want to give yourself time to hire a process server and to serve them. If you've given them 21 days to respond, there's plenty of time. Meaning, you're going to give yourself 9 or 10 days to serve the other party. All right, and then you have to you bring the proof of service to the court. Okay, and you can even do that, a couple of weeks in advance. You can show up to the clerk's office and present it to them, saying, "Listen, I have a date on a docket on such and such a date. I want to submit this evidence that they've been served. That way they know that you're moving forward." Okay, it's also called, the respondent to answer. Okay, you could put it in the petition that the respondent must respond 10 days after service. Okay, so in the petition it could say on such and such a date, the defendant must respond within 10 days of service of process of receiving summons to appear in court. Okay, that way we got everybody moving. This is very important. All right. Okay, now here's something, and it's all here. Seeking monetary damages for property seized unlawfully can be 7 times the amount taken. Think about that. So let's say they've stolen $7,000 from you. You can ask for $79,000 now. All right, it's in the Bible. The minimal cost for injuring a dujour, he must restore 7 times what has been taken. Proverbs. Okay, listen, they used to study the Bible, lawyers. Okay. All right, and there you go. The case laws, right? And I'll just move the slides, right? So that way you guys can freeze it and look at it. All right. All right. So this is what I'm going to do now. I'm at 32 minutes. It's a long video. I apologize, but this is very important. Okay. To close out, you want to file a petition in court. You're the petitioner. You're taking action against them. You're taking offense. Remember, I just showed you that you could petition the court for free. Okay. For free. And again, to show that you mean business. All right. All right. So, right. Slide 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. Okay, this is, now I'm going to give you case laws. A lot of you probably already have this. This has been all over the internet, but I'm passing it on to you. This is good stuff to have. All right. And I'm sorry, but I had to squeeze it in. You guys can figure it out. All you got to do is, freeze it and, view, and you can use the view to so you can zoom in. All right. Okay. Case laws. 11th Amendment does not protect state officials. They do that all the time. That's one of the first things they'll do. They'll claim that they have judicial immunity or they have 11th Amendment immunity. That's not, see, there is no immunity for against from arrest. If they commit a crime, there's no judicial immunity for a crime. So we have plenty of evidence. Corruption of authority. Okay. Dismissal of suit. So when a government official or a state official, these fake judges and judges, they do not get relief when they violate a federal law. Well, what's a federal law? Well, 18 USC 242. But again, we're comparing it, but it's an act. They could be charged with it. Okay? There's no judicial immunity against a crime. Like, again, it doesn't mean a judge can get off the bench, walk from around the bench, walk up to you and punch you in the nose, and then walk back and say, I got judicial immunity. Okay, a crime is a crime. There's no judicial immunity against a crime. Okay, habeas corpus. And that's it. All right, guys. I'm sorry it's a long video, but I think it's important. All right, we got to start thinking outside the box. All right, we got to start, taking the fight to them. Okay, let's take the fight to them. All right, guys. Have a good night.